The text came at 6:42 a.m.
Call now.
No greeting. No explanation. Just urgency. My stomach tightened. My lawyer, Andrew, didn't dramatize. If he texted like that, something was wrong. I called immediately. "Have you signed anything recently?" he asked without preamble. "No," I replied. "Why?" There was a pause. Papers shuffling. "Your daughter filed a petition yesterday," he said carefully. "She's claiming you're no longer mentally competent to manage your finances." I stopped breathing. Don't miss out on the journey. Subscribe and let's grow, laugh, and learn together. What? She's requesting emergency guardianship. If approved, she would gain control over your assets, accounts, property, everything. Everything. I had built my estate over 40 years. Real estate, investments, a small manufacturing company I started in my 30s. It wasn't just money. It was my life's work. "She can't just do that," I said. "She can try," Andrew replied. And she did. Apparently, my daughter had submitted affidavits claiming I was confused, forgetful, and financially vulnerable. She attached a recent incident where I forgot my debit card at a restaurant. One mistake. Framed as decline. And here's the part you need to hear, Andrew continued. She also filed a motion to freeze certain accounts, pending review. My pulse pounded in my ears. Why would she do this? Another pause. She's listed personal financial distress in her declaration. Significant debt. Of course. Over the past year, she had hinted at money problems, asked about early inheritance, suggested I simplify my estate plan. I had refused gently, but firmly. I believed in structured trusts, not blank checks. She thinks if she's appointed guardian, Andrew said, she can liquidate assets under the justification of care expenses. Care expenses. I was 67, healthy, running my company daily. This wasn't concern. It was strategy. "What do we do?" I asked. "We respond aggressively," he said. "First, we file a formal objection. Second, we demand an independent medical evaluation. Third, we present evidence of your active business management. And the account freeze? I've already contacted the bank. They won't act without a court order." Relief flickered briefly. "But here's the twist," Andrew added. "She scheduled the hearing quickly. She's trying to push this through before you can organize." Underestimating me. That was her first mistake. By noon, I was in Andrew's office reviewing documents. My company's financial statements, board meeting minutes, signed contracts from last week, emails proving I negotiated a six-figure deal just days earlier. Cognitive decline? I had closed a merger on Tuesday. We compiled everything. Then Andrew leaned back and said something that chilled me. She also attached a draft of a revised will. My heart dropped. A revised will?
Yes.
Leaving the majority of your estate to her outright. Minimal oversight. Immediate access. She forged a will? Drafted. Not executed, but attached as evidence of your prior intentions. So this wasn't panic. This was planned. The court date arrived faster than I expected. She avoided eye contact when we entered the courtroom. Her lawyer spoke first, painting me as aging, stubborn, resistant to help. Then Andrew stood. He presented medical records showing excellent cognitive health, testimony from my physician, financial reports, video recordings from recent board meetings. And finally, he said calmly, "We'd like the court to note that the petitioner attempted to preemptively position herself as sole beneficiary through an unexecuted draft will." The judge's expression changed. "Ms. Carter," he addressed my daughter directly, "guardianship is a serious measure. It is not a financial planning tool." Silence. Her lawyer shuffled papers nervously. The petition was denied. Immediately. But the judge didn't stop there. He ordered a review of potential financial exploitation. My daughter's face went pale. Outside the courthouse, she tried to approach me. "You didn't have to embarrass me," she said sharply. I looked at her, really looked at her. "You try to take control of my life," I replied calmly. "That's not embarrassment. That's accountability." She walked away without another word. Later that evening, Andrew called again. "There's one more thing," he said. "What now?" "Because of the filing, you're entitled to amend your estate plan immediately, without delay." I smiled slowly. "Good," I said. Because greed doesn't just reveal character. It rewrites inheritance. That night, I sat alone in my study. The courthouse paperwork spread across my desk. The denial of her petition brought relief, but not peace. What she attempted wasn't impulsive. It was calculated. Documents drafted. Timing planned. Language crafted to make me look fragile. If she was willing to declare me incompetent in court, what else was she willing to do? The next morning, Andrew and I began restructuring everything. Not emotionally.
Legally. Strategically.
First, I established an irrevocable trust for the majority of my assets. Independent trustees. Corporate oversight. Clear distribution terms tied to responsibility benchmarks, not age alone. Second, I updated my power of attorney. Not to her. Not to family. To a neutral fiduciary bound by strict legal duty. Third, I inserted a no-contest clause into my will. Any beneficiary who attempted to challenge or manipulate the estate without merit would automatically forfeit their share. Andrew reviewed the final draft carefully. "This will protect you," he said. "I'm not trying to punish her," I replied. "I'm protecting what I built." And that was the truth. Over the following weeks, my daughter sent messages, some defensive, some apologetic, some subtly blaming me for not trusting her. Trust isn't demanded. It's demonstrated. She hadn't come to me with transparency about her debt. She hadn't asked for structured help. She went straight to court, attempting to take control through force of law. That changes things. I didn't cut her off completely. I'm still her parent. But contact became measured. Boundaries became formal. Conversations documented. What she saw as a shortcut to inheritance became a permanent lesson in consequence. Months later, Andrew called with an update. The judge had flagged the guardianship attempt in court records as financially motivated and unsupported. That no would follow her future filings. Greed had left a paper trail. And as I looked around my office, the company I built, the framed photos from decades of work, I felt something stronger than anger.
Clarity.
My lawyer's text had warned me just in time. But what it truly revealed wasn't just her plan. It revealed the importance of protecting your legacy, even from those you love. 6 months later, the silence between us felt heavier than the courtroom ever had. My daughter eventually asked to meet. Not to argue. Not to defend herself.
Just to talk.
We sat across from each other in a quiet cafe. She looked tired, not defeated, just older somehow. I panicked, she admitted. I thought I was drowning. "You could have asked for help," I said gently. I was ashamed. That I understood. But shame doesn't justify betrayal. I told her the trust was permanent. The structure would remain. If she wanted support, it would come through transparency, accountability, and boundaries, not control. She nodded slowly. For the first time, the conversation wasn't about money. It was about consequences. Greed nearly cost her everything. But honesty might still save something more valuable.